In this video, we're going to talk about what are information disclosure statements, IDSs, what are the differences between design patents and utility patents, and what is the concept of double patenting. So first, we're going to talk about how to figure out what the filing date is. So you're going to look and see if there's a certificate of mailing. If there's a certificate of mailing, then the date that you put the application in the postage in the mailbox, that's going to be the effective filing date. If you don't have a certificate of mailing, then it's going to be the date that it's received. Next, in order to be an inventor, you need to have at least one claim in the patent. There are two different types of claims. You could have independent claims, which are claims that don't make reference to any other claims, or you could have dependent claims, which are claims that refer to other claims in the patent application. You could have disclaimers where you give up one or more claims in the application and it's going to protect the rest of the application. There are a couple differences between design patents and utility patents. And design patents are going to protect the exterior appearance of something, and it's going to look very similar to trademarks and copyrights. They're going to have a D in the beginning of them. The drawing is considered the disclosure. You get 15 years from the grant, and you could only contain one claim. Whereas in a utility patent, it's going to be how something works. You get 20 years from the effective filing date, and there's multiple claims. The concept of double patenting is when you have the same invention and you file it in two different patents. It's typically not allowed. However, there could be two different reasons. First, you could have anticipation, where it's not going to be able to be overcome if it's anticipated, meaning there's prior art. However, if there is obviousness, then you're going to be allowed to overcome this double patenting restriction if you file a terminal disclosure, which is going to be essentially giving up the term of the two patents so that they're going to be in sync and they expire at the same time. Information disclosure statements disclose material information to the patent office. They're going to have to be timely filed and they have to contain minimum content. And they're allowed to be filed 3 months of filing or before the first action. If they're after that, but they're before the final rejection, you're going to have a fee or a statement, which is going to contain information. If it's going to be after the allowance or final action of the patent application, there's going to be a special processing fee, and you're going to need to include the statement. Complete applications require a specification that contains a description, at least one claim, and any required drawings in the application. Applications can incorporate essential material that is in a issued U.S. patent or in a U.S. patent application that was publication. However, they're not allowed to incorporate essential material in a foreign patent application, non-patent publication, or a U.S. patent that incorporates from a different U.S. patent. However, if you have non-essential material, it's going to be allowed. And essential material is defined as necessary to comply with statutory requirements of disclosure.